mic is live, the stage is set. Words like fire you won't forget. Every topic, every thread. Living stories in your head. Turn it up, feel the beat ignite. Conversations flowing bright. In your ears, day or night. This is the sound that feels so right.
As always, everything we discuss is for entertainment and is speculation. Please like and subscribe, and definitely join our discussion in the comments. If you're ready, let's get into it. Welcome back to Typically Unique. Today I am reading the alternative perpetrator documents. There was a new one released at the end of last week. I'm going to go back and I'm going to read all of the court documents related to that, and we'll look at the dates as we go. So the first one is from February 21st of 2025, and this was the state's motion in limine regarding alternative perpetrator evidence. I tried to go back further than this to see if this was something the defense had started. Please let me know in the comments if there is that document. I went back to 2024 and looked through that whole year's documents. I couldn't find anything. So this to me looked like the first one. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court in limine for an order prohibiting the defendant from offering alternative perpetrator evidence or argument without first satisfying the court that any such evidence is relevant and admissible pursuant to IRE 401, 402, or 403. In support of this motion, the state refers the court and counsel to State versus Meister, where the Idaho Supreme Court addressed the standard for assessing the admissibility of alternative perpetrator evidence. So in Meister, the Idaho Supreme Court held the Idaho Rules of Evidence, adopted in 1985, implicitly overruled State versus Larson. And then it cites their citations here. The proper analysis is under IRE 401, 402, and 403, ID at 241. Citing the State versus Self 139 Idaho, the Idaho Supreme Court noted the trial court must first consider and determine whether the proffered evidence is relevant under IRE 401. The second step is to determine whether the probative value of the proffered evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issue, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. IRE 403. Noting the Larson court was concerned that a defendant will attempt to admit evidence where the sole purpose is to infer that an individual other than the accused committed the crime, the Idaho Supreme Court stated, if the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial court's discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of IRE 403. In this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of those tips were substantiated. The state submits that any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connecting person or persons other than the defendant to the homicides would do nothing more than mislead and confuse the jury, and would also result in undue delay,
waste of time, would be a needless presentation of cumulative evidence, and unfairly prejudice the state. Under the Idaho Supreme Court's ruling in Meister, this should be prohibited. The state respectfully submits that the defendant should be precluded from offering or arguing alternative perpetrator evidence without first meeting the relevance and admissibility thresholds. Okay, so that was all about the Meister court ruling. I am only reading the documents with very limited common comments throughout. So I will do a discussion video about these later on. Okay, this is March 17th, and this would be the defendant's objection to what the state just wrote, the state's motion in limine. Comes now Brian C. Kohberger by and through his attorneys of record, and hereby objects to the state's motion in limine regarding alternative perpetrator evidence filed on February 21st, 2025. More specifically, the state seeks an order prohibiting Mr. Kohberger from offering alternative perpetrator evidence or argument without first satisfying the court that any such evidence is relevant and admissible pursuant to IRE 401, 402, or 403. For the reasons set forth below, Mr. Kohberger objects to this motion. So here's their argument. Mr. Kohberger has a right to present a full and complete defense for the crimes of which he is accused. State versus Meister, 148, Idaho 236, and then they cite 239 to 40, 220, page 3D, 1055, 1058 to 59, and that's in 2009. This right is protected by the Sixth Amendment of the United States Constitution and made applicable to the states through the Due Process Clause of the 14th Amendment. And that is ID 148, Idaho at 239, 220, page 3D at 1058, citations omitted. When presenting a full and complete defense of the crimes charged, Mr. Kohberger should be given an opportunity to proffer evidence of an alternative perpetrator so that such evidence can be properly evaluated for relevancy and admissibility under Idaho rules of evidence. And then they give more citations that I am not going to read every single one. This timing of when an offer of proof is made not clear. In Meister, the Court of Appeals explained that the offer of proof was made during trial. And then it says, see State versus Meister, and they're just citing all of their evidence or their support. Two unpublished opinions provide guidance that the typical timing of an offer of proof is during trial. See State versus Meister, 2007, more citations, offer of proof during trial. State versus Buck, more citations. In Buck, the state filed a motion in limine to exclude alternative perpetrator evidence, but the court ultimately reserved ruling on the motion and ordered the defense to provide an offer of proof before it engaged in questioning on the issue. The state argues that literally thousands of tips regarding possible perpetrators were received by law enforcement during the course of the investigation, and that none of these tips were substantiated, with exception of information regarding the defendant. The state is correct that over 45,000 tips have been disclosed, and tips can continue to come in daily. This case is full of alternative perpetrators, and there's a footnote. See sealed memorandum in support of motion to suppress regarding genetic information. So in this document, they are citing the sealed memorandum about genetic information. I'll have to make a note of that. The state has chosen to focus on Mr. Kohberger at its own peril. Mr. Kohberger will produce offers of proof related to many alternative alternate perpetrators in this case that will meet Idaho rules of evidence 401, 402, and 403. Many alternate perpetrators can be connected to the crime. Conclusion: the court should deny the state's motion in limine regarding alternative perpetrator evidence. Alternatively, the court should reserve ruling on this motion until Mr. Koberger provides an offer of proof that can be evaluated under the standard for admissibility set out in State versus Meister. Okay, that was that one. So that was March 17th. Now we're going to March 21st. Okay, this is dated March 21st, 2025. It's the state's reply to the defendant's objection to the state's motion in limine regarding the alternative perpetrator evidence. Comes now the state of Idaho by and through the Latah County prosecuting attorney and submits the following reply to the March 17th, 2025 defendant's objection to state's motion in limine regarding alternative perpetrator evidence. Although the defendant purports to object to the state's motion and asks that the court deny the same, see motion at page 3, in truth, the defendant appears to be substantively in truth, the defendant appears to substantively concur with the legal standards articulated by the state in support of its instant motion, State v. Meister. And then there's a citation. The defendant acknowledges that he must make a satisfactory offer of proof prior to offering or arguing an alternative perpetrator theory. Consequently, the court should grant the state's motion and enter an order prohibiting the defendant from offering alternative perpetrator evidence or argument without first satisfying the court that such evidence is relevant and admissible. And then they cite the parts about State v. Meister that address that. Under the authority of Meister, which cites approvingly to State v. Self, and the citation for that, the defendant's proffer or offer of proof must include evidence specifically connecting person or persons other than the defendant to the homicides, recognizing that more inferences that another person could have committed the crime will most likely not be relevant. And if relevant, will still be subject to the limitations provisions of IRE 403. The state further requests that the court set a reasonable deadline for the defendant to make any proffers of proof regarding alternative perpetrator evidence or argument sufficiently prior to trial, so the issues can be fully reviewed by the court, appropriate admissibility decisions made, and the parties prepared to proceed accordingly. So that was March 21st of 2025. This is going to be the newest document from June 13th, 2025. This is the defendant's reply to the state's objection to the defendant's offer of proof regarding alternate perpetrators and defendant's evidence in support of offer of proof regarding alternate perpetrator. Comes now Brian C. Koberger by and through his attorneys of record and hereby responds to the state's objection to defendant's offer of proof regarding alternate perpetrators and defendant's evidence in support of offer of proof of alternate perpetrator, filed on June 6, 2025. Whether rooted directly in the due process clause of the 14th Amendment or in the compulsory process or confrontation clauses of the 6th Amendment, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. Crane v. Kentucky, and then it cites the information for that. The error excluding such evidence is reviewed de novo on appeal. I would have to look up what de novo is. U.S. versus Shryock. There's the information where you can find that. Due process rules trump evidentiary rules. U.S. versus Lopez Alvarez. And then the information of where you can find that. That looks like it's from the Ninth Circuit from 1992. When reserving its ruling on the state's motion in limine regarding alternative perpetrator evidence, the court stated, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. To Clifford S. Fishman and Ann Toomey McKenna, Jones on evidence, and this is citing where that's from. C, order memorializing oral rulings on motions in limine. The state has listed blank as trial witnesses. So there's a list of names here. The state has listed these unknown names as trial witnesses. The state has also disclosed and labeled exhibits that it intends to use at trial, which include the names or actual video of these witnesses. These exhibits include, and then it names the exhibits that we can't see that include these witnesses. Each of these alternative perpetrators identified by defendant and listed as witnesses by the state are more closely tied in knowledge, opportunity, and possible motive to the crime than Mr. Kohberger. All four of the alternate perpetrators are linked circumstantially or directly to the crime. Moreover, given Mr. Kohberger's expert disclosures that more than one person committed the crimes, other evidence supports the defense theory that Mr. Kohberger is not the person and the crimes were committed by more than one person. Defendant's offer of proof, in part, arises from the state's motion in limine regarding alternative perpetrator evidence filed on February 21st, 2025. On page 2 of that motion, the state argued, in this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. And then it says, with the exception of information regarding the defendant, none of these tips were substantiated. While it is true that there are thousands of tips, somewhere in the range of 45,000 to 75,000 tips, and they continue daily, the state has chosen to present evidence of investigations into the specific named individuals and the conclusion that the state has ruled out these possible perpetrators. The state's purported diligence in ruling out possible perpetrators, especially those with close connections to the victims, is an issue that state is putting front and center at trial in its own case in chief. And here's a footnote. It says the court cannot consider or weigh the strength of the state's conclusion that a suspect has been cleared in deciding if the defendant's evidence is admissible. Holmes versus South Carolina. So they're citing this case, Holmes versus South Carolina from 2006. Forensic evidence existed, but could still be refuted by third-party perpetrator evidence of a person in the neighborhood. It was reversible error to exclude it. So again, they're talking about forensic evidence. Where it was that footnote at? Right there. Mr. Kohberger has the right to confront this evidence. The state argues that the evidence submitted in the offer of proof is inadmissible, as explained above. Much of it the state seeks to admit in its case in chief. More importantly, in Chambers versus Mississippi, the United States Supreme Court held that a defendant's constitutional rights to a fair trial and to present a defense sometimes require admission of evidence of third-person culpability, even in the face of evidence rules that would exclude it. Hearsay may be admissible in such cases because the 6th and 14th Amendment rights to due process, to confront and cross-examine witnesses, and to call witnesses is never precluded. And then there's a citation there. Fairness and trustworthiness of the evidence are important. Mr. Koberger's proffer includes details that allow this court to see that there is trustworthiness to the basis for naming 4 alternate perpetrators. The police reports and tips submitted as exhibits in the offer of proof are documents that provide basis to show a link to the case that is more than speculation and grounds that explain the subject of cross-examination or direct examination of witnesses. While the tips themselves may be inadmissible, they are evidence that this court must consider in determining if there is a link and more than mere speculation. When evaluating alternate perpetrator evidence for case link or nexus, some courts demonstrate a willingness to admit purely circumstantial evidence that a third party committed the crime. And then it cites U.S. versus Stever. Some courts hold that even when the state's evidence is purely circumstantial, the third party culpability must clearly point to a specific third party. For example, some act connecting the alternate suspect to the crime. And that's People versus Salazar, State versus Clark. Okay. In Jones versus Wood, the Ninth Circuit noted that the evidence at Jones's murder trial was primarily circumstantial in nature and concluded that the state trial judge erred in excluding Jones' circumstantial evidence. So the trial judge erred in excluding Jones's circumstantial evidence that an alternate suspect committed the crime. Whether direct or circumstantial, all the alternate perpetrator evidence proffered by Mr. Koberger has both specificity of person and connection to the crime. Okay, with respect to, so this is a new paragraph. So it's starting a new topic. So it's 4 lines, so multiple sentences probably. And that's a whole complete thought right there. So we can't even begin to guess. With respect to blank. That is not a thorough investigation. That is not suspect elimination as the state argues. So, as a reader, we can use contextual evidence here. This is my teaching brain coming out, even though I said I wasn't going to make comments. She's addressing the state's inability to, she's saying inability. It's not thorough, and it's not, that is not suspect elimination. So whatever this says up here in black are the defense's reasons or examples of how it's not a thorough investigation and it's not suspect elimination. Mr. Koberger did not produce these suspects. The state did. And in some instances, continue to investigate them or simply stopped their investigation, ignoring evidence that there was more than one perpetrator. Prosecutor Bill Thompson said he would not rule out 2 perpetrators from the very beginning. And then she cites NBC News right here. Mr. Koberger's offer of proof was not an exhaustive list of all the evidence disclosed in this case that points to the 4 alternate perpetrators. In fact, the state's opposition disclosed, so here's all the evidence that, or information that the state disclosed, but it's redacted. And that is 1, 2, 3, 4, 5, 6, 7 7 lines. By listing these alternative perpetrator names on their witness list, and by listing various exhibits on their exhibit list, which pertain to these individuals, the state has opened the door for Mr. Koberger to confront this evidence and cross-examine state witnesses. Mr. Koberger suspects that the state has listed the 4 alternate suspects as a ruse to make it look as if they will put the 4 males on the stand to deny their involvement. These witnesses must be confronted, and therefore, if the state seeks not to call them to the stand, but instead uses lab reports to portray elimination, the door is opened to confront that evidence, and Mr. Koberger should be allowed to call the alternate perpetrators and other witnesses to show their connection to the crime. How each piece of evidence becomes admissible at trial depends on how the state offers it, triggering Mr. Koberger's right to confront each such evidence. Mr. Koberger must be allowed to develop this evidence, and a ruling excluding or limiting this area of inquiry at this point would be premature. The United States Supreme Court ruling in Chambers allows for, and then it's redacted. It allows for something, the admission of the evidence. So what was she talking about? She was talking about him being able to confront the evidence. The state agrees at a minimum to this confrontation in its objection. The court should allow Mr. Koberger to present alternate perpetrator evidence. Okay. I will be back with more documents and a discussion probably during my walk and talk live about what we read in there. I'll see you back on the next one. Bye.
Thanks for watching, hope you felt the spark. Please hit that like before it gets dark. Subscribe, it's free and keeps us going strong. You're part of the crew now, right where you belong. Join us next time, same truth, same fire. We bring the heat and never tire. We're typically unique and proud to be a husband and wife in podcast harmony. Epically unique, yeah, that's you and me. Don't forget to like and hit subscribe, it's free. Come back again, we'll be right here with truth and laughs and zero fear. We don't always agree, but that's the show. One love, two minds, letting it flow. We dig deep with crack jokes, we call it like we see. If that's your vibe, you belong here with me. We don't always agree, but that's the show. One love, two minds, letting it flow. We dig deep with crack jokes, we call it like we see. If that's your vibe, you belong here with me. We don't always agree, but you felt the spark. Please hit that like before it gets dark. We dig deep with crack jokes, we call it like we see. If that's your vibe, you belong here with me. Thanks for watching, hope you felt the spark. Please hit that like before it gets dark. Please hit that like before it gets dark. It's free, it keeps us going strong. You're part of the crew, now right where you belong. Join us next time, same truth, same fire. We bring the heat and never tire. We're typically unique and proud to be a husband and wife, and wild to be a husband and wife in podcast harmony. Yeah, that's you and me, that's you and me. Don't forget to like, hit subscribe, it's free. Come back again, we'll be right here with truth and laughs and zero fear.